looks like Mr. Azultine, I may be pronouncing that wrong, is had a fairly recent warrant. I would, if we're comfortable addressing that on the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
This issue is actually very straightforward when you break it down. A court's authority is determined by the weight of the evidence, not by personal arguments or technical wordplay. The most important factors are the time, date, and location connected to the citation. If the record shows that the citation was issued within Thurston County and at the stated time, then the Thurston County District Court clearly has the legal authority to hear the case. Jurisdiction exists because the event occurred inside that court's geographical and legal boundaries. As for the claim that no valid case was presented, that argument does not apply here. This matter falls under civil proceedings, where that particular defense does not legally function. In simple terms, it is not a recognized challenge in this type of case, and does not affect the court's authority or the validity of the filing.
And I have some questions before I feel comfortable with this court moving forward. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yeah. If you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azultine. So I'm going to strike Ty Azultine's hearing and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
And just like that, he's no longer present. That outcome is surprising, especially considering how patient Thurston County courts and Washington courts overall tend to be with defendants who miss a scheduled appearance. In many cases, the system is willing to offer understanding rather than immediate consequences realistically. Resolving this situation would have required very little effort. Acknowledging his legal name, explaining the absence, and offering a brief apology would likely have resulted in a new court date. Courts routinely allow that option, particularly when someone shows up voluntarily and takes responsibility instead. The outstanding warrant remains active. That means the issue doesn't disappear. It simply waits. At some unpredictable moment, possibly during an ordinary part of his daily life, law enforcement could step in and enforce the warrant, leading to an arrest and time in custody. With that matter unresolved, attention now shifts to the next courtroom figure in this ongoing pattern of cases. This one was first highlighted on Collins' channel, and viewers can find a direct link provided in the description for additional context.
Calling case number 24 RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
This entire situation could have been resolved far more simply. A brief, honest statement acknowledging one's identity would have saved the court significant time and effort. Instead, unnecessary arguments and distractions only complicated matters that didn't need to be complicated at all. When someone refuses to engage with basic legal realities, it doesn't make them clever or strategic. It only delays the inevitable. Courts are built to address real issues, not word games or avoidance tactics that in the end. Cooperation would have required far less effort than resistance. Accepting responsibility early on often leads to better outcomes, while refusing to do so only creates longer delays and more serious consequences.
Very well, Mr. Mathis. Today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, near Washington, in the City of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
As the magistrate has already made clear, the court is not required to entertain repeated or unrelated questions at this stage. What's being overlooked here is a very basic procedural point. This informal hearing was requested by the defendant, not imposed by the court. That choice comes with specific responsibilities because this is an informal civil proceeding. The next required step is straightforward. The defendant must enter a plea related to the civil infraction itself. Avoiding that requirement or attempting to redirect the process does not pause the case or change how the court operates. Personal statements, symbolic claims, or references outside the legal framework have no standing in this setting. The court's process is structured, and participation means following those rules. Without a proper plea, the hearing cannot move forward in any meaningful or productive way.
I solemnly swear the testimony you shall give before this court shall be the truth, so help you God.
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, magistrate, at that
And
time.
that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in terms of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak?
The location is actually quite clear. It's roughly 15 miles north of Detroit, which is something the defendant should already be familiar with, considering that's where the traffic violation occurred. The facts surrounding the stop are not vague or mysterious, and the record clearly reflects where and why the citation was issued. This situation also highlights a common mistake, relying on internet advice for legal strategy. So-called alternative legal theories often recycle arguments that only apply in very specific criminal cases or in civil cases involving direct harm to another person. Those arguments do not automatically transfer to every type of legal matter that are in cases where someone is accused of causing real injury or harm. Defendants do have a constitutional right to confront their accusers. However, a routine traffic infraction, such as running a red light, does not fall into that category. The legal standards are different, and the process is much simpler. Because this is not a case involving direct injury or serious criminal charge, the city is not required to physically present every piece of infrastructure or personnel in court. The law allows these matters to proceed based on documented evidence, not theatrical demonstrations.
Please bring the
Court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code of the city of Royal Oak as it is adopted.
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward. As far as the injured party, no one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case.
Why are you trying to
under the Motor Vehicle Code, as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party,
It's difficult to understand why some individuals fail to grasp such a basic legal reality. Claiming to have no defense or refusing to present one does not protect a person in court. It does the exact opposite. The legal system doesn't pause or collapse simply because someone declines to participate properly. In fact, choosing not to offer a valid defense often accelerates the process toward an unfavorable outcome. Courts rely on evidence and procedure, not silence or symbolic resistance. When no meaningful response is given, the court is left with little choice but to rely solely on the evidence presented against the defendant rather than serving as a strategy. Refusing to engage legally is essentially an open invitation for a ruling to move forward without opposition. Participation matters, and ignoring that reality almost always leads to predictable results.
injury, you guys are.
Officer Moran, any rebuttal testimony?
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank you.
All right.
Judges like this are truly impressive. They move the hearing forward efficiently and make sure the proceedings aren't dragged out unnecessarily. By ending the discussion promptly, the court avoids giving the defendant any additional opportunity to derail or confuse the record. For those wondering what happens next, the options are straightforward, though both come with a personal cost. The individual can either pay the fine in full and close the matter, or post a bond equal to the fine and request a formal hearing with a prosecutor. In either case, the city recovers its funds, and the individual is required to take responsibility for their actions. It's a clear outcome that enforces accountability without unnecessary delay. That wraps up today's video. Thank you for sticking through to the end. If you enjoyed the coverage, please give the video a like. If not, feel free to hit dislike, but don't forget to leave a comment sharing your thoughts. And make sure to subscribe with notifications turned on so you won't miss any future updates. This is Team Skeptic, signing off, and we'll see you in the next video.